Good evening and welcome to our program. Our guest tonight is Professor Lea Brilmayer, Howard Holtzman Chair in International Law at Yale University. Welcome, Professor.
Thank you.
I understand you had a very important job to accomplish.
Yes.
And you look young to do that. I mean, what's your experience?
I graduated from law school in 1976. I have 24 years of experience as a professor of law, and I've taught international law at 6 or 7 law schools in the United States, Columbia, Harvard, Yale, University of Chicago, several other ones, and now I hold an endowed chair in international law at Yale Law School.
Mm-hmm. Who is Howard Holtzman, the one you introduced?
He's a very famous alumnus of Yale Law School who donated money to raise a chair in international law. He's actually a judge, an arbitration judge, so he's very proud. Mm-hmm. He's very proud of our big success.
Okay. How significant is the ruling on international arena, the Eritrean and the Yemeni dispute of the
Well, one of the subjects that I teach is international maritime law, and this case is probably going to be the most important case for at least a decade, and maybe longer in maritime delimitation. In fact, it's the first case that was ever decided under the United Nations Convention of the Law of the Sea, which only came into force in the early 1990s. As a result, all of the practicing international lawyers, academic professors of international law around the world have all been waiting for this decision. It's a very significant decision that gives an idea about the direction that maritime delimitation law is going to take in the future.
So do you think it will get into the law books as a classic case?
There's no doubt about that. I'm afraid that for many years I'm going to have to teach this case to my students.
Eritrea versus Yemen?
Yes. Eritrea is very famous now in international law.
So that was something positive that came out of one of the positive things. Okay, speaking about outcomes, how did the dispute get to arbitration? How did it escalate to that level?
As you may know, the dispute started in 1995. The islands in the middle of the Red Sea were unoccupied, and the Republic of Yemen placed military on Hanish Island with the rationalization that they were interested in building a hotel. The Eritrean government, of course, responded to this, and there was fortunately, a short-lived conflict, and the two states realized that the only way to solve the problem was through legal processes. The mediation of the government of France was very important in bringing this to arbitration. An arbitration agreement was signed, and the legal process was started.
Mm-hmm. What was the proceedings conducted at? What was the city?
There were 2 phases, as you know. The first one was the territorial sovereignty phase. The hearings on that were held in London at the British Foreign Office. By the courtesy of the British government, they supplied us with rooms for our hearing. The second phase was held at the International Court of Justice Great Hall, which is the room that's used for the most important cases in international law. That was held this July, and it resulted in the maritime delimitation.
Okay, so this is an ad hoc sort of thing. It's not under International Court of Justice.
That's right. We used the room that the International Court of Justice uses for their hearings, and it's a very beautiful and very solemn room. But in fact, this was not a case brought in front of the International Court of Justice. The institution that sponsored our arbitration is called the Permanent Court of Arbitration, and it has some loose institutional connections with the World Court, the International Court, but they're separate. As you know, arbitration is not really the same thing as going to court. With arbitration, the two states choose their own judges, and those judges only operate for the purposes of that particular case. As we say in law, it's an ad hoc proceeding.
Well, what was the legal process, if you would take us mentally through the process itself? Is it like a regular court? Criminal court, or
in some ways it's very similar. There are similar rules of evidence. There are oral arguments where the lawyers present the case, but there are also some differences. There's no one accused of a crime. The two states come into the process on a completely equal footing. But the process is similar in that very complicated papers are prepared. We spent about 2 years preparing our historical case for the first part of the proceeding, and then about 6 months preparing our materials for the maritime delimitation. So the parties file very extensive written materials, and after those are exchanged, there's a hearing where the lawyers present the case.
But there is no such a thing as a defender and the prosecutor as we know it. And why is that, though? I mean,
that's because sovereign states are always equal to one another. And we weren't accusing Yemen. Yemen was not accusing Eritrea. It was simply a matter of two states that start out on an equal basis, both having a claim to the same thing. So there's no reason that one state should have priority over the other. They start out completely equal.
So they start simultaneously on the same ground.
Yeah.
Okay. What was the basis of Eritrea and Yemen's claim for the areas on two phases?
Yeah. The Eritrean claim, of course, rests on the Italian colonial history. And it was an established fact that in 1929, the Italian government placed troops on Hanish Island, and then Zuhur shortly after that. For 10 years, there was an established permanent Italian military presence on the island. They regulated fishing. They required Italian fishing licenses issued in Assab. And essentially, they ran the islands as they would have run any other part of Eritrea. The tribunal did not accept our argument that this gave a full basis for the Eritrean sovereignty claim. They felt that Italy had not taken the necessary steps to perfect its legal title, and that's what the tribunal concluded. The second half of our argument was based on the very extensive Ethiopian naval presence in the islands during the Federation period and then during the period that Eritrea had been incorporated into Ethiopia. During that period, Ethiopia patrolled the islands very extensively. We have detailed documentary records of the visits of different Ethiopian patrols. It was partly to regulate fishing, but more importantly because it was suspected that Eritrean liberation fighters were present on the islands and the Ethiopian government was trying to control that activity. That was the basis of the Eritrean claim, and of course when after the fall of the Mengistu government, that naval activity came to an end. Now, in the period that the Mengistu government had left Ethiopia, it was no longer patrolling the islands. And during that time period, Yemen started for the first time in history to conduct activities in the islands. And the tribunal decided that neither Italy nor Ethiopia had perfected its legal title, which left the islands open, not owned by anyone. And the tribunal decided in the first phase that the activities that Yemen undertook in the early 1990s were adequate evidence to establish a Yemeni title.
So the award, do you honestly believe that the awards are sort of affirmative action, political strictly, or there is a judicial unequivocal?
Well, of course we respect the decision, but as part of respecting the decision, we have the right to feel critical of the decision. We don't agree with the decision that was reached. Of course, we abide by it because it's a decision that the tribunal made, and we submitted our case to them for a definitive resolution. But at the same time, we feel that it was mistaken for the tribunal to look exclusively at the period since the fall of the Mengistu government, because that was the only period in time that Yemen had engaged in any activities on any of these islands.
Okay, on the second phase, on the maritime issue, what was the base for the ruling on that?
Probably the most important factor at that point was that the tribunal had already decided that Yemen did not have a history of owning the islands. Because Yemen had not historically owned the islands, they were always used very extensively by Eritrean fishermen. And as I mentioned, there was the long history of Ethiopian naval patrols in the islands. They were effectively, factually, under the control of Ethiopia. What that meant was that although there had been some Yemeni fishing in the islands, the predominant users had been Eritrean users. The tribunal felt that even though this did not create effective title, legal title to the islands, that it was a historic interest in the islands that had to be protected. The result of this was that the islands were not used to give enlarged maritime areas to Yemen. Normally, one would think that if a country owns an island, it owns the water around those islands. But the tribunal made a very important exception to this general principle in our case, specifically on the basis that historically the islands had been under the factual control of Eritrea, Ethiopia, and Italy before that.
We have a map right here in front of us, and I'll lift it up, and maybe we can get a tight shot on this. Can you?
Yes, this is a map that comes from the decision that was issued a week and a half ago. And the important thing to see is the way that this line is drawn halfway between the coastline of Yemen, the mainland coast of Yemen, and the mainland coast of Eritrea. Now, to repeat what I said a minute ago, one would normally think that islands located here and here would push the line over to the west. Normally what you would do would be to draw the line halfway between these Yemeni islands here and the coastline of Eritrea. The tribunal explicitly refused to do this, and the reason that it gave was the unique history of these islands as always being under the factual control of the country on the western side of the Red Sea. They drew a line that completely ignores the fact that these islands are there. Jebel Altair and the Zubair Islands are given no effect on the line. This line here is drawn as if those islands simply did not exist. This was in strong contravention of Yemen's argument. Yemen had argued that the maritime delimitation should be halfway between here and the coast of Eritrea, and you can see from this map that that didn't happen. Now, down here, they did give a minimal effect to Zuhar Island and Hanish. And they had to do that because if you continued a line halfway between the mainlands, it would cut directly through Hanish Island. So the tribunal decided to push this line over a little bit to give some space to Zuhar. Down here, you probably can't see it very well because the islands belonging to Eritrea are small and they may not show up. But the line was drawn halfway between Hanish Island and small Eritrean islands called Southwest Rocks and the Haykok Islands. So essentially the tribunal gave to Yemen's islands the minimal effect that was legally possible. And that is what is so distinctive about this award, that although it did not give the islands to us, it gave them to Yemen with only the minimal maritime spaces.
Okay, speaking on maritime, there is such a thing as international servitude and traditional fishing rights. Can you elaborate on that?
That's the second respect in which this decision was very respectful of Eritrean rights. It's the second respect in which the tribunal accepted Eritrea's arguments in their entirety. We felt that the history of the fishing, the Eritrean fishing in these islands, established a right on behalf of the people of Eritrea to continue to fish in these islands. Now, as you saw on the map we had a moment ago, the islands do fall within the maritime spaces of Yemen. They're on Yemen's side of the line. And normally what that would mean would be that Eritreans were not allowed to fish there unless Yemen gave them permission. But the Eritrean people have a history of fishing in those islands, and it was important and well enough established in the eyes of the tribunal that the tribunal felt that there should be historic protection for these rights, so that the people of this country could continue to fish in the places that they had fished before. So they created what they called a regime of traditional fishing rights, which gives Eritrean fishermen a right to continue to fish in all of those areas.
Okay, did you, by any chance, did you gather any information like interviews with the fishermen on the ground, on the islands, on their views?
Yeah.
I mean, what did they say? I mean, how do they feel about this?
Well, we haven't had a chance to talk to them since the decision. In fact, it was one of the most interesting parts of preparing for this case, which I have to say has been possibly the most interesting experience
so
of
there
my
was a
life.
contact?
Very much, very much. I couldn't go personally, but other lawyers working with me went not only to Assab, but went up the coast to Barasole and Id to interview the fishermen. And they had very interesting and unique experiences. One of the elderly fishermen talked about being a child and fishing around Zucker Island when the Italians were there. And he told a story about how at the end of the day, when the Eritrean fishermen were in their boats fishing in the sea, the Italians, who had their military post on the island, would lower the Italian flag. He said at that point, everyone in their boat had to stand up and salute the Italian flag. It was very interesting experience to meet these people and to feel that we might make a contribution to preserving the rights that they had for their own children and their grandchildren.
The tribunal itself, does it have any cultural sensitivity, customs and religion to people who live in these islands, and how does it work?
They tried. They realized that this was a culture that was a unique culture and unfamiliar to them. And they tried to understand it. I think maybe if they had actually come to the area, they would have had a better understanding, and that would have been nice. But they did try to understand that, and I think that's part of the reason that they felt that it was important to respect the historic rights of the people living in the area. They could have simply drawn a line down the middle, and in some respects that would have been a very simple solution. When they decided to recognize the traditional rights of the Eritrean people, they did something that was legally very unusual. It gives Eritrean people rights on Yemen's side of the line. And that's unusual, and it's going to be something that requires cooperation between the two countries. But they didn't do the simple thing because they realized that the culture and traditions of the people involved intermarriage, mixing, friendship between the fishermen, that this was a unique culture that had to be preserved. And that's why they took the unusual step that they did to create this traditional regime of fishing rights.
Okay, now that the lines are drawn, is there any mechanism that would follow the compliance? Is it foolproof or waterproof, so to speak?
It's unfortunately the tribunal has now disbanded. That's one of the things that happens in an arbitration because the judges are only chosen for purposes of this particular case. They've now left to go back to their usual jobs. This means that we don't have anyone to go back to if there's a question in the future. And it's a long opinion with a lot of legal arguments in it. It would certainly be convenient if there was a way to get a definitive answer to some of our questions. We don't have that. All we have is a history of cooperating as best we can with the Republic of Yemen and the hope that we go into this process with good faith, that Yemen will join us in exercising good faith, and we have to solve these problems on our own.
Okay. Professor, how did you get involved with this case?
I have a history of involvement in this country that goes back to just after the referendum when I came here for the first time. And so there were several years when I was doing various smaller legal projects for the government. I have to confess that when I came here in 1993, I fell in love with the country and simply volunteered to do whatever the country might think was useful. So I did a number of different things, and at the point that the conflict on Hanish Island erupted, there were people here who knew me and asked my opinion about the case. It was clear that the work that needed to be done could not all be done here. There were legal materials and historical documents that were present in Europe and in the United States. And so I became involved in collecting documents, in writing legal analysis, and it became a full-time job for me. And one thing led to another, and I organized a team of other lawyers and research assistants, and I found myself 24 hours a day involved in the Hanish Islands litigation.
Okay. So are you on sabbatical from Yale, from your law teaching?
I'm not technically on sabbatical. I haven't taken a leave of absence, but Yale has been extremely generous to me. They give me the time to travel here when it's necessary. They've supported me with research assistance, with library facilities. They've been very generous to me, so I've been able to do this without taking a sabbatical. Of course, they're also very proud.
Okay. What's the moral of the story? What's the international community to gain out of this dispute and its settlement?
Every time that two countries can resolve their problems peacefully, it contributes to the international rule of law. The fact that Eritrea and Yemen, who differed and clashed over islands in a very strategic location at the southern part of the Red Sea, where there are shipping lines, where there's a possibility of oil reserves, the fact that two countries with such important national interests at stake could set aside their differences and resolve these by legal means, it's a very good example. And of course, Eritrea, although it was disappointed, it obeyed the first decision. In fact, we were given 3 months to obey the decision, and this government made a point of obeying within less than 3 weeks. That kind of record is noticed by the international community. And the Republic of Yemen has done the same thing now. They have said, we're disappointed in the ruling, but what matters is that we agreed to submit this case. Every time something like this happens, it contributes to the rule of law, and we hope that it sets a good example in the region and outside the region.
Who else worked with you in this case?
I've been working on the case since the beginning. When I started, of course, I was working with the Zulkar Hanish Commission, which is a group of professionals in the Eritrean government, historians and lawyers and so forth. And they were the most important group that got this enterprise started. When it became a strictly legal as opposed to a diplomatic matter, I was joined by other outside lawyers. There was an American law firm that worked with us in the first phase and a British law firm that worked with us in the second phase. And both of these law firms were very generous. They worked for us on a basis that was much more generous than what they would ask for the usual commercial client. So we're very grateful to them for the job that they did. In addition, I had several young volunteer lawyers from the United States, former students of mine. There were 2 young women who helped me to prepare for the arbitration hearings. I had a young man who's now a law professor in California who did very extensive work in the office here and helped to prepare for the hearings. And I had some research assistants who did a document collection, a very talented young Eritrean man who lives in London who has a law degree from Cambridge. We've been supported by so many people inside the Eritrean government, at Yale Law School, at New York University Law School, where I taught for many years. Honestly, I can't tell you how many hours of time went in by people who are working out of a sense of the thrill of building something together with this country. It was the experience of a lifetime for me.
Okay, and of course you have had contacts with Eritrean authorities. What's your impression on that? How did it go?
Well, as I said, when I came here in 1993, I was completely taken by the Eritrean experience and by the people here. I've worked with people here in the government that are as talented as anyone that I've ever worked with in 23 years of teaching law, as committed and as intelligent as anyone that I can imagine. For me, it's the honor of a lifetime to be able to work with the people that I've worked with here.
Okay, Professor Lee, thank you for coming to our studios, and if you have anything else to add, you're more than welcome to do so.
Only to say thank you to the people of Eritrea for giving me this opportunity.
Yeah, okay, and I wish you a happy New Year, happy millennium, of course, and we hope to see one another in a different, in a better situation, of course.
Thank you, and Ruhus Harishamet.
Dear viewers, thank you for watching, and see ya. Good night.